hello, and very good afternoon, everyone. Welcome again to ABC Learning. Those who have joined now, so this is our fifth session on AIPR and our second session on patents, and we will be discussing filing of patents and PCT filing. And we have with us Mr. Pankaj Mistoni. Mr. Pankaj is a postgraduate in pharmaceutical sciences with specialization in drug regulatory affairs and pharma management. He is a registered patent agent and an advocate enrolled at Delhi Bar Council. Having over 10 years of experience, he has worked on a broad range of matters related to regulatory framework for pharmaceuticals, medicinal products, agrochemicals, pesticides, and public health products. And regularly, he advises on patent filing, prosecution, drafting, legal, and regulatory issues. He's concerning therein. Mr. Pankaj also specializes in IP portfolio management, due diligence litigation, IP strategy for technology, and business strategy. He has several publications to his credit and also has delivered lectures at various forums. Thank you so much, Mr. Pankaj, for joining us today. I'm sure we will definitely have a great interactive session. As you can see, we are a very small group of participants are here, and we can have a good, engaging, interactive session. So I'll just hand it over to you. Over to you, Mr. Pankaj. Thank you.
So I hope we have already discussed about the patent search. So when we are talking about any invention, so the first criteria is to search whether there are certain criteria for patentability. The one is novelty, another one is inventive step, and third one is industrial applicability or utility in some way. So we understand that because if we are talking about any invention, there must be a problem solution approach. The inventors who are working on any inventions, they will first identify a problem and then propose a solution. So patent search primarily helps in getting the idea whether there are any documents in public domain which can later on create a problem for grant of patent. So this will give an idea whether we should go ahead for filing of patents and other investments. So the next step is filing of patents, and we will also understand the PCT filing route. So coming to, we understand that we have gone through a search. We can take an example of any invention, and we understand that we got a very good search results that the invention is novel, and we have identified certain documents for the inventive step as well. So the first criteria is the filing of filing of the patent application. Of course, when we are talking about filing of application, it should be in a proper manner. Like if we are talking about any literature or any paper publication, then we know there is a set format. We have to mention the abstract, introduction, then review of literature, and accordingly we have to identify the problem and then the solution and whatever experimental data we have done, and then the conclusion and results. Similarly, for filing of any application, we have certain criteria, certain heads, like we have to define what is the title of invention, what is the field of invention, and accordingly what is the background the inventors have identified, and then a detailed description of the invention. So whenever we are talking that if we have developed something, if we are working on something, so is it necessary to disclose all the things? Yes, it is necessary, because in lieu of disclosing the information only, we will get a protection in form of patent right or in form of any intellectual property right. which is granted by the government. So when we file any patent application, then accordingly it will be published after 18 months from the priority date. So this is just like the paper publication when we do certain kind of experiments and we send it to some journals, and then the reviewers will review it and accordingly provide their comments, and then it will be published. So, but there is no bar from the publication here when we file any patent application, except if this contains any information that is not uh, necessary to disclose, or basically that is the information which is falling inside the Department of Atomic Energy. So, if we are filing an application which is detrimental to the safety of the country, so it will not be published directly. The application will go first through Department of Atomic Energy, and if we receive the clearance, then it will be published. So this is a very clear process. Like we can, if we file any application, then it will be automatically published after 18 months from the date of filing of application, or the date of priority. So whenever we are talking about priority, the priority is basically the date of first filing. We will understand it later in the slide of PCT filing. And when any application is published, then this application will be open for pre-grant opposition, and this will be open until the grant of patent. So pre-grant we can understand that if we file any application, then obviously it will be published. Then it will be examined by the patent office. But patent office will not automatically examine this unless we will file a request for examination. So there is certain fee involved in this when we file an application. Then we have to submit a request for examination. The due date for this request for examination is within 48 months from the date of priority or from the date of first filing. Then the patent office will examine the application and give the written examination report, which is usually known as office section in other countries and first examination report in India. After that, there is a timeline of 6 months to comply or to reply to the all the objection or all the requirements maintained by the patent office. Then subsequently, if the patent office is satisfied with the response to the written examination report, it will directly grant the patent. In case the patent office maintains certain objections, then there is an opportunity to the applicant, to the inventor, for an oral hearing. This is usually conducted between the technical examiner and the inventor or the applicant, or if we are filing it on behalf of any applicant, like a lawyer can file it, a patent agent can file it, the application. So they will present the case before the controller, and eventually, based on the discussion and the mutual discussion, and if we comply with all the objection, then the patent will be granted. And after the grant, similarly, like the pre-publication, there will be a post-publication of grant as well. So there is one option of pre-grant opposition and post-grant opposition. So pre-grant opposition is basically uh, this is open for until grant of patent, and it usually it is a process like anyone can file a pre-grant opposition. Who can understand that the patent is not a valid, or the patent is something misleading, or should not be granted. So in that case, the process is like we can file a pre-grant opposition, and then patent office will examine the representation, and then eventually he will give an opportunity of hearing to both the parties, who is filing the pre-grant application as well as the inventor or the applicant. Similarly, in case of there is no particular timeline, and this is open until grant of patent. But if the patent is granted, then there is a time bar of 12 months for filing a post-grant opposition. So this is a normal flow of patent application process. So now we can discuss there are what are the different kind and types of application. So we can have a provisional application, ordinary or non-provisional application, convention application, PCT international application, PCT national phase application, patent of addition, and divisional application. So we will go one by one. Like a provisional application is filed when an invention is under experimentation isn't finalized. So it's a kind of preliminary application, and it is based on first to file system. Uh, this is to claim the priority. So we can understand that this is also important to protect the date of priority. So we can understand by way of an example, like if we are developing any formulation for suppose we are developing any formulation for paracetamol in combination of paracetamol and diclofenac for treating pain and analgesic to reduce the fever and as well as to subside the pain. So whenever we are doing an experiment, and the intention is to commercialize it, get the benefits out of it to the public. So usually it took a long development. One has to initially one has to prepare the formulation and then accordingly perform certain experiments. And then again, in case of the human, the drug intended to application in human and as well as animals. So there is a criteria for doing the clinical trial. So it may take some time. So accordingly, what we can do that we know that we are developing a formulation particularly, so we can file a provisional application so that we can procure the date of priority, and then we can file a complete specification within 12 months from the date of filing, from the date of provisional applications filing. So this indicate that we have a 12-month period so that we can get the experiments done, and then we can convert it to the complete specification. So another one is the ordinary or non-provisional application. So we can directly, if we have we have done all the experiments for any invention, so we can go ahead and directly file the complete specification. And basically, it can be directly filed or subsequently filed. So, as I already told that in case of a publication, there are certain heads. So, in case of a complete specification or patent draft, so we have certain heads to explain it better to the patent office and also to the public. So the title is there, preamble to the invention, field of invention, what is the technical field of invention, background of invention. This primarily discloses about the prior arts we already know while doing or proposing the invention. We have to clarify the objective of invention, the statement of the invention. If the invention is supported by any drawings, models, so we have to specify the brief description of drawing and then a detailed description of the invention followed by claims and abstract. So this is the claim part is more important because this will exactly define the overall the crux of the invention. Similarly, there are application which is convention application, which is filed for claiming a priority date based on the same or substantially filed invention in any of the convention countries. Like as earlier discussed, one of the delegate is discussing with Dr. Shivani that if we file any application in US, then if we want to file it in India, so the convention timeline is of 12 months. So we can file application that we have filed already an application in US, and we are claiming a same priority date here in India. So we have to file this application within 12 months in India. Then there is PCT international application. So this PCT international application is basically a streamlined process which is governed by Patent Corporation Treaty, which is PCT, and this provide a time frame of 30 to 31 months to file in various countries. And the advantages is like the priority date would be the international filing date. So if we file any application in PCT, then we have time frame of 30 to 31 months to decide whether to decide the other countries for filing. And there are certain other benefits like this application provides an international search report which gives you the prior arts. It also provides an option for requesting for an international preliminary examination report, which also provide an opinion regarding the patentability of the invention, which is also important in a later stage. And basically it also provides the applicant on inventor, so he can amend the application in accordance with the desired rules or set patterns in any other countries. And also because the patent application uh, not only filing but prosecuting the application is mm, uh, a little bit costly. So before investing in multiple countries. So PCT, if we have a report from international search report, so we have some understanding that where we can file our invention or not. So PCT national fees application. So basically, when we file any international fees application, so this is not internationally means the international application means we have to procure the priority date for this filing, but this is not automatically an international application, and we have to enter the national fees applications in each of the countries the applicant wish to proceed. Like we are talking about the 30 and 31 months. So there is a timeline. So when we enter in 31 months, this will be treated as PCT national fees application. There are two other applications like patent of edition and divisional application. So patent of edition is like if the applicant finds something a slight modification of the invention which has already been applied, so he can file a patent of edition. Like if we say an example, if we are if we are working on a combination of paracetamol and diclofenac for analgesic and uh, pain reliever, and definitely if we come across during the examination and during the experimentation that there can be one more use of this combination, like it can be used to substitute if there is any modification to the proposed invention, a patent of edition can be filed. Similarly, if the applicant choose to divide an application and furnish two or more application in a particular application, which is containing more than one invention together, so a divisional application is can be filed, and this is basically for this divisional application and patent of edition, the priority date would be considered that as of the parent application. So next is the patent prosecution flow. So we understand that if we file any application, then after the publication up to the grant, the phase is usually known as the patent prosecution. So there are certain provisions for filing an expedite examination. Like we said that we have to file a request for examination within 48 months from the date of priority. So there is certain provisions for filing the expedite examination as well, which is available for startups, educational institutions, small entities, and natural person having at least one female applicant. And when we select corresponding PCT, has selected Indian Patent Office as ISA, International Search Authority. So this particular benefit is available for filing any Indian patent application. So we know that RFE has to file within 40 months uh, from the earliest priority date, but it can be filed. Like if we file an application today, we can file a request for examination together with filing of application. Similarly, for reply to FER, which is the first examination report, this is a report which we received from the patent office, and timeline to reply is 6 months, and we can also file an extension of 1, 2, or 3 months, but we have to take extension only once. And in case if a hearing is appointed based on if the patent office or the controller maintain the objection. So the applicant has an opportunity for the hearing, and for this hearing as well, if the applicant is not available, so request for adjournment can be filed by paying the official fee. This is 5,000, and this we can file this request for adjournment at least 3 days before prior the scheduled hearing date, and but the adjournment is available only the 2 times. And then after the hearing, we have to submit a written submission within 15 days from the date of hearing, so that after filing the written submission, if the controller agree, agrees to all the objection, and the applicant complies with all the formal requirements, then the e-patent certificate um, will be issued. Or if the patent office is not satisfied with the answer or with the invention, then a refusal decision will be issued. So coming to the formal requirements, if we are talking about filing an application, so we can there are certain forms like form 1, which is application for filing the patent application, and it contains various declaration. Particularly, this is also known as the proof of right, because uh, this application form have the signature of inventors. Also, if we are using any biological material, so this is important to disclose this information in form 1 as well. Form 2 is the description of the invention, like provisional or complete, and we have already discussed the different heads for filing a Form 2. Then Form 3, we have to disclose the details of corresponding applications filed outside India. In case I have filed an application in India, and accordingly I have submitted the applications in other countries, so we have to disclose the information to the patent office. Form 5, declaration of inventorship by the applicant. So, because this is like when we are working, a group is working on certain kind of invention, and the applicant is either institute or large entity. Suppose a group of 4 members is working in a multinational company, and they want to file an application. So the application will be filed in the name of that company, but Form 5 is need to be given that to the names and affiliation of the inventors, individual inventors. Then we have to submit Form 26, the power of authority. And basically, if the applicant is directly filing the application, there is no need of power of authority. But when the application is filed by a patent attorney on behalf of applicant, so we have to submit this. This is then again Form 18, which is form for filing a request for examination. So there are certain associated fees like cost for patent of filing an application. Uh, the basic patent filing fees is only 1600 for individuals, a startup, MSME, or educational institute. And for the multinational or large entity, this is 8,000. And for the specification and claims, if the specification document is up to 30 pages and there are only 10 claims, so there is no additional fee. But if the specification exceeds 30 pages or more than 10 claims, then we have to pay per page or per claim fee. Uh, Early publication. So usually the patent application will be published after 18 months from the application priority date or filing date. But if anyone wants to opt for early publication, then we have to submit a Form 9 with payment. So, like the government fee is 2,500 for individuals or startups, MSME or educational institutes, and for large entities, this fees is 12,500. And accordingly we have to file a request for examination. This is except for the large entity, the fees is 4,000 and 20,000 for large entity. And there is a process for fast track examination, but the fees is comparatively higher for the large entities, around 60,000, and it will fast track the application. So we can see because there is only two segregation. One is natural person, startup, and small entity. So, and another one is a large entity, or we can simply say the multinational organization. So, this is the official fees for both kind of applicant. Similarly, after a grant of patent, as we know that we have to maintain the patent by paying the renewal fee. This can be done within 3 months from the date of grant, and there is also extension of 6 months available for filing such renewal fee. And renewal of any patent application is subject to the applicant's strategy for the future or the future plan, and accordingly uh, they can pay the renewal fee based on their understanding, because the total term is 20 years. So this can be paid, the annual fee basis to be paid for third to 20 years. So one can pay for in as a cumulative, or one can pay for third to 20 year one together. Similarly, we have to submit a statement regarding working of the patented invention on a commercial scale in India. So this is usually provided in Form 27, and this is a standard format that we have to provide the quantum and value of working in India, or whether this is imported into India. So this is about the national fees filing procedure. So before that, um, when we discussed about certain forms, so so we can see that this is the form 1. So like in Form 1 itself, there is a category of application, whether this is ordinary, convention, PCT, national fees application. So this is an example of PCT, national fees application. It means the application has already been filed in PCT, and now the applicant is entering in to the national fees in India. So this is a multinational company, so we have to provide the applicant details, nationality and country of residence and address of the applicant. And for the inventors, also in similar line, the name, country of residence and address of the inventor. So title of invention need to provide, we have to provide the authorized registered patent is in India, and his or her address of service. So like we are talking about the claiming priority. So this is the priority when the earlier application has been filed in outside the India. So we have to provide the details here. that the application is already has already been filed in other countries. So this is basically to calculate the date for other activities. Like if we are talking about maybe this application is filed in 2020, but the date for examination will be calculated on the basis of the claiming priority. Like the earlier priority for this US application is October 24, 2019. So the application, the request for examination due date will be calculated from that date on. So in case of international application number, we have to provide the international filing date as well, and then declaration by the inventor. So this is usually a proof of right document. So this will be executed by the inventor. So as we discussed that there is this is necessary uh, to disclose whether the invention used any biological material from India. So this is crossed because this is a PCT national phase application. But in case of Indian applicant, and if they have used any biological material from India, so this needs to be corrected. So we have to mention the number of pages as well, so that we can calculate a fee, like completed specification, number of pages, number of claims, abstract, number of drawing. So based on this, the fee will be calculated. So like we see that we have to provide the statement and undertaking and declaration. So we will see in other example. So like we have to file we have to file the details of other countries. So this is the usual format. So applicant will provide a declaration that they have filed an application in other countries. So this is necessary to give. So this is a form 5. So we can see that the name of applicant is Indian Oil Corporation Limited. This is a company, but it is necessary to provide the details of inventors as well. So this is a format for providing the details of the inventor. So I hope I am audible, right?
Yes, you're okay.
Okay. So
Yes.
I think we will complete this first, and then we'll take the question. So basically, the earlier discussion is related to uh, a patent filing procedure in India, and another one is international filing procedure. So this is a usual timeline we discuss. Like we can file a provisional or regular application or a non provisional application, and then for filing a PCT convention or completed specification is 12 months. Then we have to if the applicant wish to enter the national phase application, the timeline is 30 to 31 months, and they want to file a divisional application or patent of addition. So this will be before the grant or issue of the parent application. So this is basically a more clear picture. Like if we are talking about any convention application, so applications in the designated countries. And apart from the designated country, the official fee would be there. The fee for local agents would be there, and the translation cost, of course, like if we are filing any application in Saudi Arabia, then we have to translate it in the local language. For the PCT application, we can file the first application in India. We can say by way of an example. Within 12 months, we can file a PCT application. Then, from the date of filing, in 16 months, the international search report will be issued, and publication would be on 18 months. Then there is the optional that we can file demand and ask for the international preliminary examination. And for this, we have to pay the additional fee, and then definitely after that in 28 months we can have the report on patentability, and then we can enter the national phase on 30 and 31 months. So there is a difference, one can say that what is the difference in filing the convention application and PCT application. So the primary difference is of the timeline. Like we can file an application in India, and then if I have to go for a filing only in US and EP, so either I can choose the convention application route or PCT application. But if I have already in mind only one or two countries, so I can go through the convention application. But uh, it will give us a 12-month time. But when we are filing a PCT application, then it will give us a relaxation of 30 to 31 months time. So basically, this timeline is for arranging the finance and for assessing the market for the particular invention. And accordingly, if we are not sure that what kind of a strength of our invention is carrying. So it can be assessed during international phase because international search report will be issued. Then we have an option to get the opinion from the international authority. And similarly, but in case of a convention application, we can get the strength of invention only after the filing. Like if any applicant has filed an application in US and then he is entering into the India, so he can get the results of the examination report only after the file. Similarly, if we are talking about any amendments in the specification or claim, so this is usually based on the national patent laws to the individual country. And uh, if we want to amend any specification during international stage, it can be allowed in the PCT application. Uh, but obviously, the time for grant is comparatively shorter in the convention application because this is allowing a time period of 12 months only to enter. But in case of 31 months, the timeline is usually extended because one can file an application on the last date of the 31 months as well. But if one can file if one has certain strategy factors, so the applicant can file it before the 31 or 30 months end. So basically, this is an advantage. Like PCT contracting states have now 157 states or 157 countries. So if any applicant, if an applicant is filing a PCT application, he has a time frame of 31 months applicable to the 157 countries. So this is a more specific timeline for providing the search report and also to get the international search report and the opinion. So when we file any application in India, so we understand that Indian patent application will examine the application. But in case of any international searching authority, so there are certain designated patent officers who will examine this application, like Austria, Australian, European, China, US, Swedish, and Indian patent offices also and international searching authority when we file a PCT application. So one can choose while filing the PCT application regarding the International Search Authority. And if we are talking about the timeline of 31 months, so we can see that US, Japan, Spain, China are allowing within 30 months. But EPO, India, UK, Australia, Russia, they have timeline of 31 months to enter. Coming to the contents of a PCT application, we have to submit a request. Then obviously the setup pattern is like similar to the national fees application or the completed specification. We have to provide a description, drawings, if necessary, set of claims and abstract. And the PCT application, if we see the official fee for filing a PCT application, uh, would be around US $470 for a large entity, and it's 94 USD for a small entity. But also it varies on the number of pages and claims. So, coming to the examination report, specifically for the PCT stage, this will give you an idea of international patent classification symbols, which we will receive in the patent search report as well. So there will be indication of the technical areas related to any finding of lack of unity, a list of relevant prior arts, document for checking the patentability, and also uh, with regard to certain claims, whether this will be considered or not. So we can see this is an example of an ISI, which shows the different category of documents. And like this is an X category. So this is important for novelty and inventive step. Then the Y category, which is also relevant for examining the inventive step. And third one is category A, which is general state of the general state or uh, of the document, which may not be relevant to your patentability of the invention. And similarly, we can see that in this application, total 12 claims has been filed. So the examination report is particularly highlighting uh, about the relevance of the particular prior art with reference to the specific claims. So these documents, when the application will be published, then the international search report, written opinion, this all are made available to the public on the BIPO website, and we can extract the documents from there onwards, and also a copy of these documents and search report will be provided to the applicant or the agent of applicant. Similarly, when we talk about the written opinion, so this will give an idea about like we can see that this is particularly showing the patentability assessment for the claims. Like in this application, 16 claims have been filed. So for the novelty, the search report is clearly identifying that the claim 16 is not novel. Similarly, the industrial application, this is clearly defining that the claim 3 to 16 is industrially applicable, and claims 8, 10 to 12 are novel, having inventive step, but claims 3 to 7, 9, 14 to 16 are lacking in inventive step. So, also, the written opinion will provide a clear reasoning for the documents which they have cited. Like this particular example is showing that the independent claim one is and the prior art document is considered to represent the most relevant art, and that the relevant subject matter is already covered in these patent documents. So, but we discussed that this international preliminary examination is an optional process, but it will give an idea to with regard to the patentability, particularly so that because the applicant has the opportunity to amend the description, claims, drawings before the national phase. So, if we have any report in hand, so uh, we can modify the description, claims, and drawings while filing the national phase application. So, as we discussed, the PCT national phase application is after the end of international phase, 31 months, and PCT is only a gateway to provide the national patent system. And as if no patent is granted by the PCT, this is only for provide. This is only a process to provide entry to the national patent systems, and also to provide a certain timelines. Specific timeline, and to provide an opinion, preliminary opinion for the patentability of the invention. So this is all about the procedure.
So do you have any questions here? So you might want to ask the instructor. I think, Pankaj, we don't have any questions here for you. So thank you so much and for coming and joining us here for this wonderful session. It was brilliant. I think we had a lot of,
Right.
it was
Because
very informative and the practical insights. Yeah, please tell me.
yeah, so basically, whenever we are talking about the patent filing, so because we are bound by certain timelines, so this is necessary to remember these. Like basically, I can say that whenever we are working practically on any application, so this is the responsibility of filer, whether it will be a patent attorney or the applicant itself, to remember those deadlines, because this is only governed by the law. In case the request for examination has a timeline for filing is the 48 months from the date of priority. So if we miss that deadline, so the application cannot be revived. If we file the application and we pay the fees, and also it will be published, and but if we miss the deadline, so this is important to remember, and also to maintain a record of the deadline. So I think as a professional, this is the most important part us to remember.
I think this is what timeline is the important now within this specific timeline that you have to complete all entire process.
Right, sir. So basically, that's our job profile of a patent attorney. When we get the search result, and this is okay. Maybe the invention is novel and inventive, and if we file a PCT application, we have get the good results. But like I'm saying, 31 months deadline is to enter in India, and if one missed the 31 month deadline, so because nowadays filing is very easy. We can e-file any application. So I can see. So this is an example of acknowledgement receipt. So this application is particularly for the Form 7A. So the agent has filed a pre-grant opposition. So basically, this is nowadays very easy due to the e-filing. So we will get a receipt whenever we file. The report, this receipt will be automatically generated. So this is very important because earlier, 2015 or 16, we have to file all the documents physically at the patent office. But now you will get a receipt immediately. So this is particularly indicating the time as well. So if there is any case and 31 min deadline is so the patent office or portal will accept the application based on the exact timeline. So if there is and we can understand that if there is a deadline of today, we can file the application by 12 night only. So if there is 12/1, the portal will automatically reject the application. So this is important.
Any other questions here? You can also type your questions in the chat box. Yes. if you wish.
Ma'am, is there any question on later as well? So
Sure,
if
sure,
you
sure, sure.
write to us, we will provide an explanation.
Absolutely, absolutely. Thank you. Thank you so much, Pankaj, for joining us here today. I'm sure all of us enjoyed the session. It was quite an informative session for all of us. Thanks again. And thank you, all the participants. Our next session would be on IP office action, which would be taken by Ms. Preeti Tyagi at 3:15 p.m. So you can, sorry. So the next session is at 1:30 p.m. on techno-legal aspects of specifications, which would be taken by Dr. Pradeep. Sorry about that. So we have a lunch break of 45 till 1:30 we'll have a lunch break, and 1:30 we'll meet again for another session with Dr. Pradeep on techno legal aspects of specification. Hope that's okay, and we'll see you again at 1:30 p.m. Sure.
Okay. Thank you.
And
Thank
thank
you.
you so much. Thanks everyone. Thank you.
Thank you.
Thanks Pankaj again. Thank you all. Thanks. Bye.